Hello, I just want to thank you back to our YouTube channel where we try to provide you with really good quality information and accurate information in regards to foreclosures and also often about probate because many times those two things are coupled together. So we're just happy that you're here. If this is your first visit, welcome. And we hope you come back. If you find that the information that you hear today is useful and has been helpful to you, it might be a good idea to give us a thumbs up. That always helps, right? And to click the subscribe button because every week we put up new videos that can be really helpful and so it'd be a way for you to automatically get notified when new information is available for you. So today the topic is: can you sell real estate while you're in the probate process in North Carolina? Losing a loved one is it's a very difficult, tough time, and dealing with an estate on top of that can also feel very overwhelming. So today we're going to break down this complex topic of selling your real estate during probate in North Carolina, and we'll cover everything from the basics to what happens if the property is in foreclosure. So let's dive in and cover this topic for you. So let's start off with the basic definition. Like, what is probate? It's really just a court supervised process of selling a deceased person's estate. Think of it as like a legal checklist to ensure that the debts are paid and that the assets are distributed correctly. Real estate's often the most valuable asset that a person has, and sometimes it needs to be sold to cover the debts or to divide among the heirs. So when in North Carolina, real estate, it doesn't automatically become part of the probate estate. It's what they call it vests to the heirs. But it could be pulled back into the probate process. And vesting means it just the heirs become the owners of it. And so, like I said, it could be pulled back in. And some of the reasons it might get pulled back in is because the estate does not have as sufficient liquid cash to just pay off all of the debts that are owed by the deceased. And then the other case, it might be that the will can actually the loved one may have written in the will that they want the property to be sold. So in that case, it could be sold. Um, the property, when it is sold, it's got to be divided amongst all of the multiple heirs. And so if the state is insolvent or has significant debts, the seller selling the real estate might be the only option that you have to pay those debts. They have to be paid before the heirs can receive a benefit from the estate. So just to sort of lay out the normal uh, probate process, the first thing that happens is after your loved one has passed away, is the court needs to appoint what they either there's two different terminologies. There's an executor, which is the term they use if the deceased had written a will, and in that will identified who they wanted to be function as the executor to manage the probate process. But if there was no will, then the court has to assign someone. Sometimes it's a family member, but that person is then not called the executor, but they're called the administrator. But their roles are the same. It's basically to manage the estate. Then the executor needs to basically take an inventory of all the assets, the personal property, and they need to go through there and get, it's not a precise, but they need to get an appraisal, a value of the estates, naturally, so they can look at the value of the estate as compared to what are the debts. Um, Now, then all potential creditors of the deceased have to be notified and given time to submit their claim if they haven't already done so legally. That time frame after notification is usually like 90 days in North Carolina to submit their claim. And then the executor determines if there is enough liquid assets when they compare the inventory and the appraisal to the amount of debts and the expenses. Um, if not, the real estate, it might need to be sold to cover those debts. Now, if the will does not grant the executor the power to sell the real estate, then the executor must, if they want to sell the real estate, they must petition the clerk of Superior Court for permission to sell the property. And if the will grants this, if the will granted the power, the court approval may not be needed. So the other thing you have to make sure is that the title is clear, that you need to ensure that the property title is clear and that all the heirs are notified of the intended sale. The executor or the administrator still must get a consensus from all the heirs to go ahead and sell the property. Of course, then you proceed ahead with it. You can sell the property through with a realtor. You may have a family member that wants to buy it, or maybe a family friend, or whatever means you proceed ahead with selling the property. And after you've sold the property, the proceeds are used to pay off all the debts in what they call a statutory order of priority, and that means there's a legal order that the debts need to be paid off, and they're prioritized. We're going to talk about that next. And then after you do that, all of the remaining funds are distributed to the heirs, and then you distribute those funds to the heirs for what's left over. So, now North Carolina has a specific order for paying debts. And here's a quick rundown of it. Number one priority is the administrative cost. There's costs with administrating the probate process. So first, those costs have to be covered. The second in priority is the funeral home expenses. Those need to be paid. Now there is a cap in the prioritizing. There is a cap of $3,500 towards funeral expenses. Then the third one is the grave marker expense with a cap of $1,500. I'll explain that cap in a second. Then you have to pay any due federal or state taxes that might be unpaid. And then if there were any medical expenses for the deceased, those need to be paid. And then the wages, if the deceased had employees that had not been fully paid, then each of those employees need to be paid up to $2,000 per employee. And then after that, any other debts are just fall into the bucket of the last priority. Now, here's something important to realize when you're talking about that priority and the caps. Now, if a claim exceeds the statutory cap, like a funeral expense that might be above $3,500, which wouldn't be surprising, only the cap amount is paid as a priority. The excess is treated as a lower priority unsecured claim. Now, if there isn't enough money to pay all the claims in a case, claims are paid what they call pro rata, which means that each gets a proportional share. So I guess they look at, what is the amount that the total amount, they add up all the total amount that's left over that still needs to be paid. Then they do the division and make a proportion of how much the larger debts are going to get a larger portion. And then the last thing is the lower priority claims are paid only if the higher priority claims are satisfied in full. Now, what if the property is already in foreclosure? This adds an urgency and a complexity that we need to talk about. And here's some key points. The mortgage is what they call a secured debt, a priority debt, and the lender has the right to foreclose and sell the property to recover what's owed. Now, the lender can proceed with the foreclosure even after the owner's death, so the executor really needs to act quickly, because the whole foreclosure timeline is only like 120 days, and earlier we talked about there's a 90 days that need to notify the creditors. So it is important if you're going to sell the home, you have to act very quickly. If the property is worth more than the mortgage balance, then that means you have equity in the property, and selling it through probate could be used to pay off the mortgage, and possibly some of the funds could go towards the debts and then the heirs. Now, if the estate has funds, the executor can pay what's owed to stop the foreclosure. He could pay the arrears, the amount of number of payments and penalties and fees that it takes to bring the loan current. Another thing, the executor can try to sell the home before the foreclosure sale, and take the proceeds of the mortgage, uh, and then pay out to the estate. That's very, very challenging, especially when probate's involved, because the foreclosure timeline is so quick. But I will say this: I follow all of the foreclosures in North Carolina in this area, and I do see that the clerk of court is a little more gracious with the timeline when probate's involved, because I think they know it does take a more extended period of time. Now, if there's equity, the executor or the administrator, uh, they may if there is no equity, they may just let the property foreclose, and the lender sells the property and the state receives nothing, unless there were like some surplus funds, so the sale price went higher than expected and there was some funds beyond what was owed. That would be the only case there might be money for the heirs. Now the question is, can real estate be sold without probate if the estate is liquid? And the answer to that is a firm sometimes. First of all, if all the heirs agree to do so, and all of the creditors have been paid off, so you would not be allowed to do that until after all the creditors have if there's proof that all the creditors are paid off. Um, but if the will directs it to be sold, and there are disputes or unresolved creditor claims, the probate involvement it still may need to be involved in probate. So a little recap here. So selling real estate during probate in North Carolina is a structured process, and knowing the order of the debts is important. If the property's in foreclosure, man, that's like a red flag. You got to act quickly. And you should really consult a probate attorney for guidance, which I am not. I'm just giving good information for you. But you know what? I just want to say thank you so much for watching. I hope you found this information helpful. We do have a website with tons of informational videos like this. The website is www.foreclosuresolutionsnc.com. We're here to help you. And whether it's with foreclosure or probate, in any way we can, just reach out to us. But feel free to go to the website, and there's a blog page where you can view a lot of helpful information. And thank you, and have a wonderful day today.